The next matter to come before the court this morning is Bentley et al. Versus Equity Trust Company. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant today and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning and keep you apprised of passage of time. The court's read the briefs and are ready to proceed when you are. Before we get started this morning, I do note that we are running ahead. Are we expecting do we know if we're expecting anyone that I don't see here in the courtroom today?
Not for our site, Your Honor.
Not for ours as well.
Okay, thank you.
We're of course happy to wait if Your Honors have any preference.
Unless you're waiting for someone, we're fine to proceed. Thanks for asking.
Certainly. Good morning, Your Honors. May it please the court. My name is John Camillus. I'm before you today on behalf of the plaintiff appellant investors in this matter. Counsel, I'd like to reserve 3 minutes for rebuttal, if I may. Thank you. There are technically 3 issues as we see it, as we sort of define it before this court. One is whether the trial court erred in granting summary judgment on the plaintiff's statutory Texas Securities Act claim. The second is whether the trial court erred in granting summary judgment for the defendants on the plaintiff's common law tort claims. And the third, though it's related, is whether Ohio or Texas law applies to those tort claims. On that first issue, whether the trial court erred on the statutory Texas Securities Act claim, we think the trial court clearly erred because defendants did not move for summary judgment on that claim. They filed a partial motion for summary judgment as to the common law tort claims only. And in their appellate brief, Equity Trust conceded that the trial court erred in granting summary judgment on the statutory claim. So unless the court has questions, I intend, without being presumptuous, I intend to focus my time on the common law claims and the choice of law issues. With regard to the common law claims, I'd like to begin my argument by quoting the first 2 sentences of Equity Trust's argument as to the common law claims, because that argument, that those 2 sentences encapsulate their argument and they're a clear misstatement of the law. Equity Trust argues, and I quote, "But for appellants' account relationships with Equity Trust, Equity Trust would have had no involvement with appellants or their investments in the Langris scheme. Therefore, any duties or obligations of Equity Trust toward appellants arose as the result of those account relationships and were thus derived exclusively from and governed by appellants' written account agreements." That is not what the law says. The law has no case in Ohio, and certainly Equity Trust has never cited one, has held any sort of but-for standard for whether a contract subsumes the claims. What the law says is that if the claim is based on breaching a duty that the contract imposes, it is a contract claim. And if a claim is breached on a duty that the law imposes, even in the absence of that contract, then it is a tort claim. Batista from the Sixth Circuit stands for that proposition. Tautson, Kosciuszko from the House Supreme Court, Hollinger, they all stand for this same proposition. But under defendant's theory, if there's a but-for cause to the relationship, but for the relationship that is expressed in the contract, no relationship would exist, then all of the obligations are contract-based obligations. And that's not what the law says. And I would prefer, and I know the court has read the briefs, this is part of the purpose of our house painter analogy that we said in the briefs. If that position was correct, and that a party whose relationship would not exist but for a contract had no separate tort obligations, then the house painter, who's painting a house, sees that the family's not there, sees that the door is unlocked, and calls a thief and says, "Come take their TV," would have no obligation in tort to the homeowner, because that's not breaching any duty imposed by the contract. Clearly, that's not the law. The law is if the duty is imposed by the contract, it's a contract claim. If the duty is otherwise imposed by law, it's a tort claim. Here, the claims we have are for committing fraud, in being engaged in a conspiracy, and aiding and abetting the breach of a fiduciary duty. All of those claims are based on common law torts, obligations that equity trust would be bound by, even if there were no contract. We make no allegation in this case that equity trust breached any of its obligations under the contract. Not one. There is no breach of contract claim asserted. As a result, equity trust is wrong, and the trial court was wrong to find that the tort claims are precluded somehow by the contract itself. Equity trust also relies on two cases from this court in which it was a party, generally for the proposition that all of its obligations to investors in self-directed IRAs are what's contained in the contract, and nothing beyond what's contained in the contract. But neither case so holds. The first is Patterson versus Equity Trust from this court, but in that case, other than the breach of contract claim, the other claims were a claim for violation of Ohio Securities Act, which we have not brought, and a claim for breach of fiduciary duty. Now, on the Ohio Securities Act claim, which is not a claim that we have, this court did not rule that it was precluded by the contract, but ruled that there was not evidence that it was a security at issue. On the breach of fiduciary duty claim, the court said that under Ohio law, there is no fiduciary duty from the custodian of a self-directed IRA to an investor in a self-directed IRA. We do not have a direct breach of fiduciary duty claim against Equity Trust. As a result, nothing from the holding in Patterson is compelling here. The second case is Tarquinio versus Equity Trust. There were three supposed tort claims brought by the plaintiffs against Equity Trust. One was performing a contract, failure to perform a contract with appropriate skill and care. The second was breach of the duty as a bailee, and the third was breach of fiduciary duty. Again, the court held that there was no fiduciary duty running from Equity Trust to the investors. We take no issue with that and have not alleged such here. The court held there was no facts establishing that Equity Trust was a bailee. We take no issue with that and have not alleged such here. And the court properly held that performance of a contract with appropriate skill and care is not a tort claim. It's a contract claim, because in those allegations, a plaintiff is complaining about the way in which a defendant met or failed to meet its obligations under a contract. So by law, that is a contract claim. None of the reasoning or holdings in Tarquinio apply to preclude any of the common law tort claims that we have brought here. I would also note that Equity Trust's citation of Tarquinio is dangerously misleading. Equity Trust quotes Tarquinio essentially for the holding that given the contract between the investors and Equity Trust, no independent tort duties arose. If you review the Tarquinio opinion, it contains no such holding. Rather, it says, Equity Trust argues that, given the contract, no independent tort duties arose. Essentially, the court was parroting Equity's argument, and then Equity has quoted it for the court's holding, which it clearly was. I'd like to briefly walk through the three different common law claims. We brought a claim for aiding and abetting the breach of fiduciary duty, two claims for fraud, and one claim for conspiracy. Under the aiding and abetting claim, in its motion for summary judgment below, Equity Trust made two arguments. The first was that Ohio law imposes there's no tort under Ohio law of aiding and abetting a breach of fiduciary duty. The second argument was that the tort claim is barred by the contract. They never argued until a throwaway sentence in their reply brief that the Langeths are the fraudsters here. They're the ones who orchestrated this Ponzi scheme. They have argued on appeal, and in the throwaway line in their reply brief, that the Langeths owed no fiduciary duty to our clients, the investors. It was not properly preserved below. It was not raised in the motion. It was raised in the reply brief. It was not developed in the reply brief. That's also the issue. The court's probably aware that defendants filed a notice of supplemental authority just yesterday. I would note first that that notice of supplemental authority is improper. Under this court's local rules, Rule 8E requires such a notice to be based on a decision that has come down since the briefing. That notice was not based on any decision that has come down since the briefing. But the argument that Equity Trust makes in that notice is that even if they had failed to raise it below, it's this issue of whether the Langdis owed us a fiduciary duty, it's still preserved because it's implicit in the claims before the court. That is not true. What is before this court is whether Ohio or Texas law applies and whether the aiding and abetting breach of fiduciary duty claim is precluded by the contract. The court need not resolve the question of whether the Langdis owed our clients a fiduciary duty in order to answer either of those questions, and therefore it's not implicit in any way in the claims that are before this court on this appeal.
Before you go on, can you walk us through the choice of law analysis?
Yeah, I'd be happy to, Your Honor. So critically on this aiding and abetting claim, we concede that summary judgment is proper if Ohio law applies. As to the other common law claims, as to fraud and conspiracy, it really makes no difference whether Ohio or Texas law applies. But aiding and abetting breach of fiduciary duty is a valid claim under Texas law. It is a claim that Ohio law does not recognize. And that's where the choice of law issue is really critical. Here we have a case that involves a scheme perpetrated in Texas by a Texas resident. Almost all of the plaintiffs live in Texas, were in Texas when they made the investments, were in Texas when they received all of the information. The loans were given for real estate in Texas. The monies were commingled in a bank account in Texas. The agreements were carried out in Texas, and the real estate is in Texas. Now, there are two different ways to approach a choice of law question based on a second restatement of choice of law. One is to apply sections 145 and 146. The other is to apply section 148. If you apply section 145 and 146, the elements to consider are, one, the place of injury. The plaintiffs were injured in Texas. Other than 4 of them, 23 plaintiffs were in Texas, 4 were in New York. So when they invested their money, for 23 of them it came from Texas, for 4 of them it came from New York. All of them were investing in real estate that is in Texas. That's the place of the injurious conduct, which is the second element. The third is the domicile of the parties. Here, 23 of the 27 plaintiffs are domiciled in Texas. Equity Trust alone is domiciled in Ohio. 4 of the plaintiffs are domiciled in New York, so Texas predominates. The fourth element is the place of the relationship. That's a little bit more fuzzy in this case as to the relationship between plaintiffs and Equity Trust. Plaintiffs were generally in Texas when they received communications, when they did their investing. Equity Trust, of course, was in Ohio.
Counsel, you have 3 minutes remaining.
Sure, I'll use a short bit of my rebuttal time to complete my answer for Judge Schaefer. So weighing all of these factors, they all generally weigh in favor of Texas law. If instead we apply section 148, the first prong is the place where the plaintiffs acted in reliance. Clearly that is Texas. Number 2 is the place where the plaintiffs received the alleged misrepresentations. Clearly that is Texas. Number 3 is the place where the defendants made the representations. That is Ohio. 4 is the domicile of the parties. Again, that is predominantly Texas. And number 5 is the place where the tangible thing that is subject to the transaction is located. That again is Texas, whether it's considered the real estate or the money. The real estate's in Texas. The invested money was commingled at a Wells Fargo branch in Austin, Texas. Under either the 145, 146 analysis or the 148 analysis, Texas law predominates and applies. It is the law that has the most significant relationship to the case. Especially because this case is being sent back down on the statutory claim. We ought to have a chance to do discovery, which the trial court cut off, do discovery into the facts underlying our common law claims. Nothing stops Equity Trust from filing a normal motion for summary judgment at the close of discovery, arguing that the facts don't support the common law claims. But there's no reason or legal justification for cutting us off from even pursuing any discovery at all as to those. Thank you, Your Honors.
Lorain App.No. I'm representing Defendant Equity Trust Company, and Defendant and Appellee Equity Trust Company. Your Honors, the standard here is important. We're here on a motion for summary judgment. Appellant is arguing the case as if it were a motion for judgment on the pleadings. It's not. Although this court has de novo review, the standard on summary judgment is clear that once the moving party comes forward with facts, the non-moving party cannot rest upon the unsubstantiated allegations in his pleadings. The Supreme Court decided this in Drescher versus Burt, and a number of other cases in this court has held the same in countless decisions. Yet that is precisely what the plaintiffs did below. The plaintiffs, although the plaintiffs had, despite counsel's representations, the plaintiffs had extensive discovery. They obtained all of the documents relating to their accounts with Equity Trust, all of the documents relating to their communications with Equity Trust, all of the documents relating to the Langut's accounts with Equity Trusts, and the Langut's communications with Equity Trust relating to those communications. They did not ask for depositions. They filed the Rule 56F affidavit of counsel, and we can talk about whether that was appropriate under the rule that requires an affidavit of a party. But the most important thing about that affidavit is that it did not, as Rule 56F requires, detail the evidence appellants expected to get or explain why they did not have access to this information without discovery. That is the standard set forth in the Fields case that we've cited in our brief. Plaintiffs made, in this case, actually four claims against Equity Trust. They've kind of consolidated them into three, but there really were four. Count 2 for aiding and abetting breach of fiduciary duty. Count 5 for misrepresentation. Count 6 for fraud, and count 9 for civil conspiracy. As counsel has conceded, 4 of the plaintiffs are not in Texas, they're in New York. But putting that aside, Equity Trust produced evidence with its motion for summary judgment. It produced all of the accounts agreements that were signed by the plaintiffs and an affidavit discussing what Equity Trust's role is as a self-directed IRA custodian. Plaintiffs, however, put forth almost identical cookie-cutter affidavits by most of the plaintiffs, not all of them, put in an affidavit. And those affidavits do not go to any of the underlying facts that counsel has argued here today. There is no evidence in the record of any misrepresentation by Equity Trust. There is no evidence in the record of any agreement between Equity Trust and Mr. Languth or Mrs. Languth or any other evidence of the conspiracy. There is no evidence of reliance by any of the plaintiffs on anything that Equity Trust did or did not do. There is no evidence that Equity Trust did anything to affirmatively participate in any fraud. And there is no evidence of any relationship between the plaintiffs and Equity Trust outside of the contracts, and this factor is critical. There's no evidence also that the Languths had any fiduciary duty to the plaintiffs. Now, all of these facts, if they exist, would be uniquely within the plaintiff's knowledge. No discovery on these issues should be necessary. In fact, there are allegations made in the complaint, and under Rule 11, counsel had a duty to make a reasonable investigation to ascertain that these facts were true. Under the Rust case, those facts cannot be what he wishes they were. They have to be real facts. And yet, when the plaintiffs put in affidavits after our summary judgment motion was filed, and when they knew what the issues were that we were arguing, they did not put in any of these facts. So what counsel has argued here today are allegations in the complaint. They are not facts in the record. There is no evidence whatsoever of any of those absolutely necessary facts that must be in the record for this court to deny a motion for summary judgment on the basis of the other facts that Equity Trust put in the evidence. There are also no allegations, or I'm sorry, there are no facts, and none of the affidavits say that the plaintiffs thought that Langruth was their investment advisor, as appellants argue in their briefs, or that he had any other relationship with them. There is nothing in those affidavits to indicate any relationship. And I'm harping on relationship here, Your Honor, because I believe that relationship is key to the plaintiff's common law tort claims. You don't get to choice of law if, in fact, there are no facts to support any of these claims, and that is the situation here today. I believe that appellants have misread the Batista case. The Batista case turns on the relationship of the parties. The actual quote, and plaintiffs cite this in their brief, is that there must be some positive legal duty imposed by law because of the relationship of the parties, rather than from a mere omission to perform a contract obligation. Now, plaintiffs fixate on the first part of that sentence. They talk about a positive legal duty imposed by law, but they completely ignore the fact that Batista and all of the other cases that the court will see before them in these briefs require a relationship between the parties. The only relationship in the record here, by virtue of the account agreements that we put in, plaintiffs did not put them in, the account agreements that plaintiffs signed, which they acknowledge in their affidavits that they entered into, that is the only relationship in the record between the plaintiffs and Equity Trust. Moreover, the cases that counsel has given you, they've given you dozens of cases that do not involve self-directed IRA trustees, custodians. They give you cases that involve other kinds of torts, personal injury, house painters, the house painter analogy. Equity Trust is not a house painter. Equity Trust is a self-directed IRA custodian. There is an enormous amount of case law, and we've given you a good bit of it in the brief. There's an enormous amount of case law describing what a self-directed IRA custodian does. These plaintiffs have not put anything in the record to indicate that they had any other expectation other than that Equity Trust would do exactly what it said it would do in its account agreement. They have not put anything into the record that would indicate that they had any expectation that Equity Trust would act in any other fashion. There is no evidence whatsoever that Equity Trust acted outside of the contract or beyond the scope of its account agreements. There are allegations in the complaint, but there is no evidence to support these allegations. This is a motion, again, I reiterate, this is a motion for summary judgment. This is not a motion for judgment on the pleadings. Lastly, I'd like to address the Hollinger case, which is, we believe, is not controlling. Here, unlike Hollinger, the plaintiffs produced no evidence that they believed, and again, this is a fact that they should have known about if they believed it, but they didn't say it in their affidavits, that they believed that Equity Trust would investigate the Langley's. The only evidence in the record is completely to the contrary. The account agreements disclaim any and all of such evidence, or, any and all of such duties. Patterson, I'd like to speak just for a minute about Patterson. There actually were negligence and intentional misrepresentation claims in the Patterson case. They were decided by the court below and dismissed. They were not appealed, and so there is a mention of them in the appellate decision. But in fact, those were claims in the case. Tarquino, again, the standard that these cases establish is not dependent on the particular common law tort that the plaintiffs were alleging in those cases. I agree, they were determined on the basis of breach of fiduciary duty claims, but they were not, this court was setting forth a standard and saying that if the account agreement disclaims duties, and the plaintiffs come forward with nothing nothing, as they have here, to demonstrate any other relationship outside of the contract, nothing to demonstrate any misrepresentation even, nothing to demonstrate any reliance, then the parties are bound by the contract. There can't be a tort separate and apart that is not based on any relationship between the parties.
Could an exculpatory clause be used to waive a claim for fraud in Ohio?
Your Honor, there isn't any evidence of fraud. Can it? I don't know. I haven't researched it. I suspect not. But in fact, that's not this case. On this record, Your Honor, we believe that the opinion of the trial court should be sustained on all of the common law tort claims. We believe that the court doesn't need to get to conflict of laws, but if the court were to get to conflict of laws, we believe that Section 148 of the restatement applies. And looking at Section 145 of the restatement of torts, it's obvious that you have to look at the precise portion of the restatement that applies to the particular torts at issue. And here it would be Section 148, and we've laid that out in our brief. These plaintiffs were in Texas, but everything that they did, all the actions that they instigated were in Ohio. They opened accounts with Equity Trust in Ohio. There's not even an allegation in the complaint that Equity Trust did anything in Texas other than carry out instructions of its account holders, which is what it is contractually obligated to do. The accounts were held in Ohio. The money was wired from Ohio. The accounts were supposed to get promissory notes back. They got promissory notes. Those promissory notes were held in Ohio. The fact that the promissory notes were connected in some way to some real estate in Texas does not make the locus of the damage here Texas. The locus of the damage is in Ohio, where the accounts are located. And Your Honor, we believe that plus the contractual agreement that the plaintiffs made that the law of Ohio would apply should be controlling, and that those factors should weigh heavily and require this court to apply Ohio law. Thank you.
So you have a minute and a half remaining.
Thank you, Your Honor. I'll try to squeeze it in. I have 3 points to try to make. The allegations of what we believe discovery will show if we're allowed to do discovery is that Equity Trust knew that the Langhas were engaged in prohibited transactions. They controlled both the lending and the borrowing arm of deals that's prohibited by federal law, and Equity Trust knew about it. Not only did they know about it, but they gave economic incentives to the Langhas by waiving the fees that they would otherwise have to pay. And then they made misrepresentations to our clients indicating that they don't fund a deal until they see the note. In fact, they never saw these notes because the notes didn't exist. When Equity Trust stands before you and argues no evidence of misrepresentation, no evidence of reliance, no evidence beyond the scope, she said no evidence beyond the scope of the account agreements, we were precluded from engaging in discovery on those things. The stay of discovery was only partially lifted, and the judge said that we can engage in discovery with regard to the duties and obligations in the contracts. We were handcuffed from doing any discovery into duties and obligations that arise outside of the contracts. Equity Trust is wrong when they say that there needs to be some other relationship between the parties in order for a tort duty to be imposed. Under Ohio law, there's Supreme Court case after Supreme Court case I can cite you. The duty is imposed when the injury is foreseeable. Parties need not have any other relationship. Ohio law imposes a tort duty when injury is foreseeable. We believe that the discovery, if we're allowed to do it, will show that injury to the investors was foreseeable to Equity Trust.
And counsel, you have reached the end of your allotted time.
Thank you, Your Honor. I appreciate it.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. Thank you. We are adjourned until Thursday here in Lorain County.